So what I wanted to talk about was an inspiration that I had recently when I was viewing the American Academy of Matrimonial Lawyers virtual conference that took place a couple of weeks ago. And James Hitchner was one of the presenters, which Janae had talked quite a bit about him. He's very well known in our world and highly respected, and I try to follow him whenever he gives output and information and insight as to what his opinions are with respect to our realm of the world. And he has a lot with COVID and coronavirus. And he said one thing in particular, and Greg, if you could move to the next slide. This is the abstract of what I'm going to be talking today. But per Hitchner, he had said, he posed the concept that it was possible to use a pre-COVID data valuation, a hypothetical condition, and still infuse the coronavirus COVID-19 factors into the cash flow. And this really intrigued me because I have a number of cases, especially in divorce, where it seems, quote unquote, it's not fair, is what I get a lot of feedback from my clients, that we are not taking COVID into consideration. And when Hitchner had noted this, I had made a point that this is something that I wanted to discuss on today's presentation and hopefully get some feedback from you all. This is something that I'm just starting to research, but ultimately what I had found after parsing the key points of the standards that I felt like were most applicable, such as hypothetical condition and subsequent event, is that COVID-19 coronavirus is a subsequent event and not a hypothetical condition. I wouldn't feel comfortable arguing otherwise, but I would love to hear how that could potentially be done. Greg, you can move to the next slide, please. This is just the direct quote. You can have a valuation date before COVID-19 was known or knowable and still value a business assuming COVID-19 and comply with business valuation standards. Greg, you can go on to the next slide. Thank you. So whenever I have a question with respect to what I'm doing in valuations, I always go back to the standards, which is great that I'm on the board now, so I can really become very intimately knowledgeable of them, as I should be. So I dug into the AICPA standards of the definition for hypothetical condition, and that which is or may be contrary to what exists, but is supposed for the purpose of analysis. And then I just pose the question, how can this be if COVID-19 was not known or knowable as of the date of valuation? Okay, Greg, you can move to the next slide. And further parsing the standards, hypothetical conditions, assumptions, and the reason for their inclusion, that's in NACVA, with the location in the standards cited there. And that initially, right off the bat, I thought of lost profits or a damages case in which I would want to include, or I have included in a situation where a contract was lost or won, and I wanted to have the effects on the cash flow be seen and be able to be quantified. And so that would be a hypothetical condition, in my opinion. USPAP goes on to say, Greg, you can go back, I'm sorry. Thank you. USPAP goes on to say hypothetical conditions are contrary to known facts of the subject property, such as market conditions or about the integrity of data used in analysis. So I just posed some additional hypothetical conditions in my opinion, such as if Trump was reelected, if Biden was put in the office, going back to my contract analogy, or here in Southwest Florida, hypothetical condition would be, I've done this before for a roofing client, when there have been a number of hurricanes on the horizon, we want to have those incorporated into the cash flow to see how he can prepare adequately. And in that situation, we would have these hypothetical hurricanes imposed, but we wouldn't have, let's say, Irma if it was pre-date of Irma coming about. Okay, Greg, you can go on to the next slide. These are the corresponding standards from NACVA, the NACVA standards comparison chart. And toward the end of my deck here, you'll see I have a source page where I have all the hyperlinks, and one of the hyperlinks is to this document. And thankfully it was before I came on board for the standards board here, because I get a feeling it was a lot of work went into this, and it's very helpful, and it's a great tool to have. So I recommend everybody take a look at it, especially if you have multiple certifications. That's where I use it the most. Okay, Greg, you can go to the next So after hypothetical condition, I did look into subsequent events so they could do some comparative analysis. NACVA standard states that disclosure of subsequent events considered may be included in the report introduction. And probably as a number of you are doing, I pulled the verbiage from the AICPA. If you're an AICPA member, you can get the subsequent event verbiage that they include. It's very succinctly put together and concise, and I put that into my reports for report dates that are post the coronavirus, but the valuation date is pre. AICPA SSBS, the subsequent event, as indicative of conditions that were not known or knowable at the valuation date, including conditions that arose subsequent to the valuation date. The valuation would not be updated to reflect those events or conditions. So that's when we get into the known or knowable aspect. Greg, if you can move forward. This is a case in which a hypothetical condition was used. It's Mistreat v. Mistreat, and a time period that I think is very analogous to coronavirus, or at least it has been in our world, it seems, is the recession and the impact that the recession had upon businesses that we were valuing versus the coronavirus and COVID now. And so this case, actually, the issue was, did the court err to revisit the distribution of the business marital asset, the value thereof? The date evaluation was pre-recession. The final judgment was post-recession. And unsurprisingly, the husband filed a motion for reconsideration due to the impact of the recession upon the company's cash flows. Okay, Greg, you can move to the next slide. Trial court said at the time of the final hearing, which was during the recession, the economy was in a downturn, and the effects of the recession, which was essentially unknown to the court, counsel, and various experts who provided testimony to the court. The court is satisfied that as a court of equity, it should permit a rehearing as requested by the former husband, in as much as to do otherwise might prove inequitable. The present recessionary economy was totally unforeseen. No one could reasonably anticipate the severity of the same, which I found that very interesting. The trial court allowed the revisitation of an event that was not even foreseen at the time of the valuation. Okay, next slide. So did the trial court err on the decision to revisit the distribution of the property? And the appellate court did think so. The appellate court said a cloudy crystal ball is no basis for a new trial, that the future in fact unfolds differently than business appraisers assume cannot be a basis for a new trial on the value of a business if trials on such issues are ever to yield reliably final adjudications. Okay, great, next slide. In Mistreat, as of the date of valuation, the recession was unforeseen, and considering it as a hypothetical condition, as of the date of valuation, was not an acceptable option. The appellate court did not want to encourage a continual revisitation of judgments based upon changes in economic conditions that were unforeseen as of the date of valuation. And to me, right off the bat, I refer back to law school with the slippery slope kind of context. And that's what I think the court was trying to avoid there. If they were to allow a revisitation of an event that happened after the valuation date and impose that into the value of the marital asset that was in question with respect to distribution, what other cases would they be opening up? And I think the docket would probably be overwhelmed. Okay, Greg, next slide, please. Hypothetical condition seems like a good workaround on one level. It's a good way to include, it seems like I was getting excited about the fact to include the effects of COVID for a pre-COVID date evaluation. But I personally would not feel comfortable as I see as posing COVID or coronavirus as something that's purely hypothetical. I did ponder this and try to think of a way in which I would say a pandemic, but it just was a hard thing for me to wrap my head around. So I personally would not feel comfortable. A predicted insight, I feel like there's one more so for COVID-19 versus the recession. So I've been following what Hitcher's guidance has been with respect to using shorter term DCFs. I too am finding, as other panelists have noted on this webinar, that on average, from the projections that I'm getting from my clients and conversations and such, that it seems to be 2 to 3 years before they get back on track to pre-coronavirus time for many of these companies and my clients. And in the courtroom here, most of the time, as probably is the case with you guys, most of the cases end up getting settled. But I think it's just a matter of explaining the DCF in a clear, succinct manner and having it be very understandable for the judge. But also, if you're in a small town like I am, you start to get to know the judges and get to know the patient's level for learning technical valuation aspects, or their base knowledge that they might already have in place. So that prepares you. It can seem unfair, and I think this sums up as a whole my deck here. It can seem unfair, yet it is unlikely that a business owner would request reconsideration if the company were to escalate in value a year after the final judgment. And I think this is, for myself personally, I've had this conversation many times, and I think it helps clear up and reduce frustrations, if not hopefully temper some kind of anger that a lot of the clients have. It seems like in marital dissolution, with situations like this, where it does seem to be unfair if the valuation date is pre-COVID, but then flip the coin, if the business were to go up in value exponentially, would that same business owner want to revisit the value at that point so that the ex-spouse could receive a higher payout for the distribution of the asset? So I think that puts things in perspective and helps people understand where the courts are coming from. Okay, next slide, please. These are all the sources and the links there too. And the next slide just has my contact information. If anybody has used a hypothetical condition and used it with a pre-COVID data valuation and assumed the effects of the coronavirus and COVID, I would love to hear how that worked for you. But looking at the standards that, as I had parsed them for this brief presentation here, I don't see how it necessarily would be. I wouldn't feel comfortable doing it, and I don't think that it should be done in such a way, because I think it's a subsequent event more so than a hypothetical.